Well, good morning. I'm speaking on a single topic today, which is two new and somewhat confounding bills that were passed, SB 699 and AB 1076. And these are two bills that address non-competition issues and covenants not to compete in any kind of agreement with employees or affecting employees. And what's frustrating is that one was a bill in the Assembly, one was a bill in the Senate. They kind of sort of cover the same ground, but of course they use different language because nobody in Sacramento ever dots their I's or crosses their T's. So we're in this position where if you read all of the new provisions that have been added to California law, it raises lots of great issues for lawyers. I mean, once again, I think that the real goal of the legislature is to keep people like me employed, but it does really aggravate employers that have to live with this stuff. Let's see if I can, perfect. So let's just do a little bit of background. As you probably know, California has what is probably the strictest law prohibiting non-competition agreements or clauses in employment and other agreements. And the law that's been in place for many, many, many years, Business and Professions Code 16600, which said in whole, except as provided in this chapter, every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. The easiest example of that would be for 1 year after you leave your employment with our company, you may not work for any competitor or any kind of restriction on accepting other employment. And the courts have consistently applied this, and the penalty was the provision is void. So when there was litigation, it was always about, well, can I enforce this or is it not enforceable? But including it in and of itself in an agreement was not per se unlawful. It was simply at your own risk. This could be voided. Possibly a court would say the entire agreement should be voided because you put in this unenforceable language. They mentioned these exceptions, and there are really only two exceptions that have existed and continue to exist. One is the sale of a business. Like if I sell my business to you, you can require me in the contract to say, I will not now set up a new company to compete with my old business for a period of time. So but that's very limited to sales of business. And the other is you always have the right to enforce protection of your company's trade secrets. So, that would not be a restraint on engaging in a lawful profession, trade, or business. And I highlighted that language because that is the language in the law. It's very broad. And this statute has been applied to other kinds of provisions. The Supreme Court has held here in California that you can't prevent a former employee from soliciting your customer, for example. Many courts, although there are a few outliers, have held that you can't prevent a former employee from soliciting your employees. Hey, I want you a new company. Hey, come with me. These have been found to be provisions that would violate 16600. So now we've got two new laws that were actually two bills that have added essentially three new provisions to the Business and Professions Code. And again, I sort of highlight, you're going to see the confusion about the language and why that's relevant. Since you're going to get the slides, I did want to have the full bills in front of you. But the first new section, so 16600A is a longstanding existing law, which uses the very broad term restrained from engaging in lawful profession, trade, or business. Then it says, this section shall be read broadly. Again, I want to remind you of that in accordance with the Supreme Court case that I mentioned that pertain to solicitation of your customers or your clients. And it says this section should be read broadly to void the application of any non-compete agreement in an employment context or any non-compete clause in an employment contract, no matter how narrowly tailored. I don't know what a non-compete agreement is. There is no definition. It's a generic term that we use. You kind of talk about restrictive covenants, covenants not to compete. They're part of the same section 16600, but A is using the broad language that all of the case law has been built upon over decades. And then the second section uses this undefined term, which in my personal opinion, and that opinion is worth nothing, I think that that's just a shorthand for this. Non-compete really means any provision that restrains someone from engaging in blah, blah, blah. But some would argue, no, they use different language in the same subsection of the statute. So maybe they have a different meaning. I don't know. We'll see why this is relevant. So again, they say it's just declaratory. This is just sort of the legislature like kind of nailing that, hammering that nail into the coffin to say, we really mean that we don't like non-competes or any restraints on engaging in law profession. Okay. And then they also remind us this section shall not be limited to contracts where the person being restrained is a party to the contract. What does that mean? This is actually really important, particularly for either the attorneys who are drafting these agreements or our HR executives. What kind of agreement might you have with another business that could potentially restrain someone from engaging in a lawful profession, trade, or business? Well, I would urge you to go look at your agreements with recruiters. Look at your agreements with temporary services agencies that are placing people at your company. There often is language that could basically prohibit someone who is on their payroll from working on your payroll for a period of time. And that is, I think, exactly what C was reminding us, that it's not just the agreement between you and your employee, but any agreement you sign. I mean, I don't think anyone's, I hope no one's doing this anymore because there's been so much litigation, but it was not uncommon even a decade ago for two employers to enter into like no poaching agreements. Okay, I agree, I won't, reach out to your employees that you don't reach out to mine. We saw that there was a lot of publicity about the animation industry, where it was alleged that some of the major animation companies in town had agreed not to poach one another because there was a big shortage of artists and nobody wanted to have their people poached. Okay, so this is really just reiterating. Then we have two more sections that were added that are creating new stuff. Okay. The first new section is 16600.1. And this section of the law says it is unlawful to include a non-compete clause in an employment contract or to require an employee to enter into a, again, undefined non-compete agreement that does not satisfy an exception. Again, those are only those two exceptions. So, okay, it used to be the provision would be void. Now we say, no, it's not just void. It's unlawful to do this. Then it says, for your current employees and anyone that was a former employee as of January 1st, 2022 or later, the last 2 years, whose contracts include a non-compete clause, who were required to enter into a non-compete clause, does not satisfy one of those two narrow exceptions, the employer shall by February 14th of this year, so you've got a little over a month, notify the employee that the non-compete clause in their agreement is void. Notice made under this subdivision shall be in a written form and individualized communication. The legal question is, well, all right, I don't have in my, for example, separation agreements. I don't say you may not work for a competitor or you may not work anywhere else while you're collecting severance or anything like that. But I do say for the next year, you won't solicit, poach any of my company's employees. Now, depending on what opinion you want to take, because there's no answer to this question, I again think non-compete clause is being used generically to mean any provision that would be void under 16600, which likely would include things like no solicitation of employees. Other lawyers might argue, no. I mean, a non-compete is something narrower. Even though it's not defined, it's got to be a more narrow term. That really means language that says you may not work for another employer or a competitor. Maybe I'm being too conservative, but I don't think that there was any express, I mean, the whole purpose of these bills was to make non-competes much more difficult to have, to maintain, to enforce. I don't think that there was any intention to make this provision narrower. God, that's hard to say. More narrow than what was historically in 16600. We also know that it's unlawful. Two things: to have a non-compete or to fail to give the notice. So you are taking a risk. If you decide, I think that the language we have, I'm not sure that it's really a non-compete. It might violate might be void, but I'm not sure. If you don't give the notice and you're wrong, then you are engaged in unlawful conduct. And they add a consequence. A violation of this section constitutes an act of unfair competition within the meaning of another provision of law, which is California's unfair competition law. The unfair competition law is a law that is very broad. It can be used in many contexts, corporate business contexts, wage and hour context, but the unfair competition law provides for various remedies, including, they don't call it damages, they call it restitution, which means you can recover anything that you lost. Like, I didn't take that job because I followed the language of my contract, so I lost a year's pay. It sometimes looks a lot like damages, but so restitution, an injunction, and attorney's fees. And I thought you have to care about attorney's fees, because the attorneys really don't care, especially if they're bringing it on behalf of the class, whether or not anybody gets anything. They only care about the attorney's fees. So we've got this. We have another new section, which is 16600.5. First, it says any contract that is void under this chapter. Okay, now we're back to the broad language again, rather than the narrow language, is enforceable regardless of where or when the contract was signed. What does that mean? Clear, easy answer. Let's assume you hire, new hire who work in my favorite state of Texas or Louisiana or someplace where you have lots of non-compete language, and you want to bring them to California. That agreement will not be enforceable in California. So even though the employee is subject to this agreement that they signed that said, I won't work for a competitor, or I won't work for any employer in the industry or whatever, if I want to hire them and they work here, California courts will not enforce that agreement. What about the court in the state where the person worked, Texas? This is where, again, great for us lawyers. What this creates is, well, the former employer goes to court in Texas to get an injunction, to sue for damages, whatever. Yeah, you probably couldn't take that judgment into California and enforce it in the California court, but it could be enforced in the other state, presumably. I mean, you get into all kinds of constitutional law issues where California is trying to impose its will outside of the borders of the state of California. Again, great for lawyers, terrible for those of you who have to deal with how to manage your business. It says it's an employer shall not attempt to enforce. So I presume if that Texas employer came to California and tried to enjoin the employee from coming to work for you, if they have a presence here in California, I guess they could be sued here. So they could go to court in their own state and probably enforce the contract, or they can come here and then probably be held to violate the law of California. Again, mind-boggling confusion. An employer shall not enter into a contract that has a provision that's void under this chapter. By the way, these were better drafters because they made it clear void under this chapter. And if you do any of these things, you commit a civil violation. So it's already unlawful, and now it's also a civil violation. Does anybody know the difference between unlawful and a civil violation? And the employee or former employee or prospective employee may bring a private action to enforce this chapter for injunctive relief or recovery of actual damages. That's the big thing. So what used to be, I may put this language in, I might have a court say it's not valid, I may not be able to enforce it, but at least it'll have some prophylactic effect. Employees might be afraid to go and violate it. Now, you're just doing something that's unlawful and that you can be sued for. And let's assume you will be sued for it, because that's what we do here. And of course, you can get reasonable attorney's fees. I think a lot of lobbyists must be attorneys. We have a civil violation, we have claims for damages, we have unlawful conduct and unfair competition claims. I want to point out that nothing in 16600 or any of its other sections prohibits you from restricting your current employees from competing. You still have the right to say, while you work for us, you can't also be moonlighting with our competitors. But as soon as the employment relationship ends, all bets are off. And there are so many unanswered questions. I mean, I'm raising just two, but I mean, we could spend days thinking up hypotheticals about different states and how it's going to apply. One question that some people have talked about is, I'm a California employer. I have an office in Nashville. Can I have non-competes in my contracts with people who are hired and working in Tennessee? I think the answer is yes. I don't see how California can in any way, shape, or form regulate my employment relationship with my employees outside of California. But there's no uniformity on that. I have read many alerts by many law firms saying, oh, this law basically applies nationwide. And if you are a California employer, you can't have non-competes nationwide. I would not go that far quite yet. If you're a multinational company, I mean, I've got some friends here from NBCU. I mean, they operate, as many of your companies do, in many jurisdictions. While I'm conservative about thinking these laws go a little further than just quote non-competes, I would not start changing my agreements or sending out notices to employees who are working in your offices or facilities outside of California. Quite yet. Now, of course, we might see court decisions that will alter our advice. But where I think the closer calls come is your remote employees. If they report into your California office or your sales offices in California, but you've got, a couple people spread out throughout the country for your regional sales, there, I think that it would be easier for someone to argue, well, this is really a California employment relationship. Even though I'm working remotely, I report in. I mean, again, there's no answer to that question, but I would probably be a little more conservative with respect to agreements with remote employees reporting into California. And really, that's it. So I don't have any easy solutions, but for your reading pleasure, when you get the slides, reread these sections and try to figure out what they were thinking, because I don't know. Your homework. Review your existing form agreements, not just employment agreements, but releases or separation agreements that employees have signed in the last 2 years. Any kind of I often find non-compete language or similar restrictions in your confidentiality, in your invention agreements. Kind of think about all of the agreements where there might be language that needs to be considered. Decide your position before February 14th. Are you going to just void every provision that would likely violate 16600 or narrowly only void the non-compete language? Consider removing California choice of law provisions from your contract. If you're hiring somebody in your Tennessee office, your Texas office, the last thing that you should be thinking is, I want to have uniformity. So I'm going to have every employment agreement say this agreement is governed by California law. I know many general counsel who will say, we like uniformity. We don't want to have different rules applied to different contracts around the country. Maybe you can figure out a way to argue that the choice of law should be Tennessee. But you never want California law, because then you may be inflicting upon yourself this law and many other California laws that are horrible on yourself. And that's a self-inflicted wound, which is not pleasant.